You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Ladies and gentlemen, the Florida Supreme Court. Please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket this morning is Florida Education Association versus the Florida Department of State. Mr. Meyer.
Good morning, Mr. Chief Justice, members of the court. May it please the court, my name is Ron Meyer. I'm here on behalf of the appellants in this action. With me at council table are lawyers in my office, Lynn Hearn and Jennifer Bloom. Your Honors, this is a case involving the correctness, or what we suggest is the incorrectness, of the ballot title and summary that has been proposed for Amendment 8 to the Florida Constitution, scheduled to be placed on the general election ballot this November.
Now, I thought that your position is that the title, first of all, you do not attack the title. Is that correct?
No, I don't.
And that actually says revision to the class size amendment.
Yes, ma'am.
All right. And as I understand it, you don't attack the summary as far as what is in there as accurately representing what is in the amendment. Is that also correct?
We believe that the summary correctly reflects at least parts of what is in the present Article 9 of the Constitution, relating to what the present goals for class size compliance are, the fact that if Amendment 8 passes, it will allow an averaging process to be used in calculating those goals rather than a per student head count in classrooms, and that also that it allows for increasing by 3 students in K through 3 and 5 students grades 4 through 12 the number of students who can be tolerated in a classroom. We don't challenge that the summary correctly mentions those items.
So your argument is that there should be reference to the financial impact of this amendment?
Your Honor, it's more than a financial impact, and I think if you'll indulge me a moment to show how we got here. You'll recall in 1996 there was a case, the Coalition versus Childs case, in which a coalition of school districts brought a legal action against the state asserting that public schools were not being adequately funded in accordance with the constitutional provision as it then read. And this court said that's not a justiciable issue. There were not standards of adequacy prescribed in the Constitution, and therefore dismissed that action. In 1998, this court said in Bush v. Holmes, in direct response to the Childs case, the Constitutional Revision Commission came in and proposed amendments to Article 9, Section 1, which was designed to put in place specific standards defining what adequate provision means, to have a uniform, safe, efficient, and high-quality system of free public schools. So it sort of addressed the shortcoming that was found in the Coalition case. Then in 2002, the people of Florida, I can only suspect tired of inaction on funding of public education, further defined what an adequate provision would have to be in their Constitution when they passed the original class size amendment, which said adequate provision, in addition to the other things, uniformity, safety, etc., must also provide that provision is made for funding of sufficient numbers of classrooms so that the goal of not having more than 18 or 22 or 25 students, depending upon the grade levels, respectively, could be achieved. The Constitution was amended in a unique way in 2002. What it said was a funding floor. It said that the legislature must not exercise the normal unbridled discretion that is given to the legislature to provide funding for education, but must start with a floor that provides adequate provision to meet the goals that the Constitution also adopted, 18, 22, and 25. That floor is what is relevant to the lawsuit before you today. Amendment 8 doesn't discuss a number of things.
Let's just go, the section of Article 9, Section 1 of the Constitution that you're referring to that was put into effect in 2002 was that the legislature shall provide sufficient funds to reduce the average number of students in each classroom, and that's the part that you're referring to that existed, or is there another?
Well, it's actually the preamble to the numbered paragraphs in Article 9. It says, to assure that children attending public schools obtain a high-quality education, the legislature shall make adequate provision to ensure that by beginning at the start of this school year, these goals can be made. And what this court said in 2002, quoting from the decision, is the primary purpose of the 2002 amendment was, quote, the legislative funding of reduced class size. That's what this amendment in 2002 was about. Now, Amendment 8 will change that. What it's going to do, if passed, is it's going to change the funding floor that the people put in the Constitution in 2002 from a ratio that is 1 to 18, 22, and 25. It's going to change that. It's going to reduce that to a ratio.
But what's wrong with that? That's what I don't understand is it doesn't seem to me that you are really quarreling with whether or not the amendment adequately informs the public of the purpose of the amendment, but that you are actually quarreling with making these changes.
No, I'm not quarreling, and perhaps I'm not being clear, and I suspect I wasn't clear at the trial court below because I wasn't very persuasive there. I hope to do better here. What I'm suggesting to you is that there's nothing wrong with the people of Florida deciding that they want to allow more kids in a classroom, that they want to change the way the kids are counted, or indeed to say we're willing to allow the state to change this base funding level that they must provide and provide less money. What I'm suggesting to you, Your Honor, is you've got to say that in the ballot summary. The summary is silent with respect to the change that is being made. If you look back at some of your cases,
Just let's go
Change
back
in
to, yeah,
funding?
just let's go and answer, if you could answer that question. It's silent as to the fact that once there's a increase in the number of students required, that naturally flowing from that will be a reduction in how much the legislature will have to fund?
the legislature is certainly free to fund whatever it wants to above this floor that is in the present Constitution. Article 9, Section 1 now sets a funding floor. It says adequate provision shall be made by the legislature to ensure that no classroom exceeds 18 students. If you allow larger classrooms, then you're also saying that you're going to allow the legislature to escape the funding obligation that's presently stated in the Constitution.
But my humble question to you is, isn't that obvious?
I don't believe it is, Your Honor. I think more is required if we're going to amend the Constitution and allow the people of Florida to let the legislature off the hook for funding education at a level that the people placed in the Constitution in 2002.
Well, how can anyone read this and not understand that if they change the size, they increase the size that's required, that flowing from that will probably be a decrease in how much the legislature or the state will have to fund? And also, I would add, I guess that for the local school districts, probably a reduction for them in how many teachers they have to, how many more teachers they have to hire. I mean, you haven't mentioned that effect.
I'm not sure that any of those consequences naturally flow. I think...
Well, maybe then if they don't naturally flow, then maybe that's not what this amendment's going to do. But we know for sure what it's going to do is change the minimum or maximum size of the classroom.
What we also know it's going to do is it's going to reduce the minimum funding that the Florida legislature has to provide to the public school districts in this state.
Do you have a number for that? How much is that?
It's not a dollar amount.
How can you ascertain?
It's a ratio amount. In other words, the ratio that is established, it says the legislature shall make adequate provisions to ensure that there are sufficient numbers of classrooms to meet these ratios. If you change them, you're diminishing the funding amount that's required in the Florida Constitution. And all we're suggesting is the ballot summary needs to tell the voter that.
You should talk about the ratios?
Pardon me?
You should talk about the ratios?
It should say that by changing from 1 to 18, 22, and 25 to 1 to 21, 25, and 30, you are also decreasing the amount of money that the state is required to pay. Because let's face...
Is that really necessarily true? Because when I read this, it talks about the maximum number of students that you can have, but it also talks about the average number of students. And so when you look at that, quite frankly, to me, I'm not sure that we're doing much by, if this amendment passes, that we're doing much in changing what it originally said.
Well, you're changing it substantially from a funding perspective. And I go back to the 2002 base amendment, which was all about funding. You'll recall in the decision in the advisory opinion to the Attorney General, the purpose of the amendment was said to be about funding, to require the legislature to provide funding for sufficient classroom space to meet these targets, to require the legislature, not local school districts, to pay the costs associated with it, and then to prescribe a schedule for implementation.
But it still says that.
But we're changing that. We're changing that funding level that the people put in place to a different level, and we're not telling them that. And that's the flaw in the ballot summary in this case. If you go back to just a few weeks ago...
just to stay on this, what do you suggest this amendment should say that would cure that? I'm not sure I'm really following.
I think if the summary had said, where in the first part where it talks about the number of students assigned to each teacher in public classrooms shall not exceed these numeric goals.
You're talking about paren A?
I'm talking about the ballot summary itself,
okay.
where they describe the current ratios that are in the Constitution,
Okay.
it should point out that the present Constitution requires the state, not the local school district, to provide funding. So that's the present provision required to provide funding to meet these goals. Then, when it goes down to changing the numeric goals, it should say something about the concomitant diminution in funding that follows. Funding from the state. Look, the school districts still have to struggle to make whatever is in the Constitution work. And what the people have said in 2002 is these are state obligations. These are not obligations of local school districts. These are state obligations. I may very well present at the voting booth saying, look, what's the difference with having 3 or 5 extra kids in the classes? What's the difference if we use an average instead of counting heads in a classroom? But I may very well have some quarrel with, by doing that, I'm going to diminish the obligation of the state of Florida to provide what's been estimated to be between $350 and $1 billion a year to the public school districts in the state.
But I think that I'm understanding what your argument is, because it's stated in your brief, but it's not, this is one part of what an adequate funding is for education, that is class size.
Clearly.
So it's only affecting the state's obligation with respect to class size, and if the voters decide that class sizes can be greater than they are now without affecting the quality of the education, they'll make that decision. But you're making it sound as if somehow, as far as other aspects of a public education, that the legislature will be let off the hook with that, and it's not affecting the other provisions of Article 9, is it?
Well, it's not affecting it, except that right now, for the past 8 years, Article 9, because of the class size amendment, has driven a fixed amount of money, the money necessary to meet these goals.
But only to build classrooms. So maybe the legislature will now have the flexibility to take, if it's whatever it's going to be that's in savings, and put it into increasing the salaries for teachers, which I would assume your group would appreciate, or some other source of quality education other than the numerical size of the classroom.
But shouldn't the people of Florida be told that you're taking away the guarantee of this flow of money that is now in the Constitution, and you're speculating on whether the legislature will give it back to you? There's no guarantee under Article 9 that the, quote, savings, which is accomplished by taking money out of local school districts and allowing classes to swell to larger sizes, stays with education. Right now, the people have an assurance, whether you agree with class size, whether you think it's the best thing for children, whether you think this is where we should put our resource or not, the fact is there's a constitutional provision driving a level of funding from the state to local school districts, so local school districts don't have to make up their losses with local taxes. If you're changing that and you're going to reduce that level of funding from the state, it's going to have an effect on local taxpayers and local school districts, and all I'm suggesting to you is the summary should tell you that.
The local taxpayers aren't going to have to pay more if there is a lower or a greater number of students per class. That's not going. How is that going to increase their burden? They're not going to get the money that the present class size amendment requires be sent to local school districts. That's the argument here. This summary doesn't tell the voter presenting to vote on November 2nd, first, that there is a state requirement in the Constitution to fund a certain level of class size compliance, a level of money to local school districts, and second, it doesn't tell the voter who presents on November 2nd that we're changing that requirement. We're reducing that level of funding. And all I'm suggesting to the court is that past precedent of this court suggests that you don't hide those facts from the voter. You go back to a few weeks ago on the Amendment 7 case. You found that Amendment 7 in the NAACP v. Roberts didn't mention contiguity. It was silent with respect to that. And yet you found there was going to be a dramatic change to contiguity. Your Honors, that's the same case you have here. You have a provision in the Constitution that's not mentioned in the ballot summary that provides a level of funding, a minimum floor, if you will, to local school districts, and that's not mentioned in the Constitution, and you're changing it.
if you pass Amendment 8, and that's not mentioned in the ballot summary.
Mr. Meyer, you're now down to less than 4 minutes.
I
You can
think
keep
I'll-
going if you like.
No, I think I'll stop now and reserve the rest for my rebuttal. Thank you.
May it please the Court, Tim Osterhaus on behalf of the Department of State and Secretary Roberts. The trial court correctly found the ballot title and summary here to clearly and fairly state Amendment 8's chief purpose in accordance with law, and that it's not misleading. From this trial summary, the voters will know that they're deciding whether the public school classes of their kids, their grandkids, their nieces or nephews will be governed by a fixed hard cap on the number of students or by an average across a number of classrooms. This amendment is not about funding. It would be similar to an analogy, I think, as if there was an amendment to increase the size of this court from 7 to 9. Now, certainly there would be some obvious funding changes associated with that, but the chief purpose of that amendment would be no different, and it would be the same as here, which is simply a change to the current status quo as to the numbers, as to the class size.
Well, I could agree
parameters.
with you if they were changing to an average so that there can be flexibility. But there's no question that by increasing the maximum number of students per class, that there is going to be most likely a very significant effect on the amount of funding provided. I mean, my response to Mr. Meyer is that that's obvious, that flows from it, but to say that it's not also, that it's not part and parcel of what's going to happen, I think is somewhat naive.
Well, I think that there is some speculation involved there, Justice Perriente.
How could there be speculation if there right now would be a class that would have, it goes, it's going to go from 18 students to 21?
That's correct.
Each of the classes are going to increase the class size.
As a threshold matter, let me remind you that the purpose of this is to change class size. But as to that argument, it's speculation, because if you read the record at pages 51 and 52, under the current class size amendment, some of the strategies that districts and schools would have to take here involve eliminating small classes, involve eliminating non-core classes, your art, your music, your PE, and essentially streamlining the educational process by focusing everything on the core requirements.
Well,
Now,
I think what we're probably suffering from, since as far as the lack of knowledge in this regard, is that we have, this came to us on a summary judgment, so all we have are the undisputed facts. The undisputed facts are that that we have what the amendment said before, and now we have this. I question what was the chief purpose of the legislature. Was it to assist the school board so they could have more flexibility, or was it to say that there's going to be otherwise a $1 billion plus price ticket on this, and we can't afford this as a state, and we don't, that's not in our record. So as far as what was motivating the legislature to act.
Well, there's also nothing in the record, Justice Perriente, that gives a figure as to whatever the decrease that they're alleging in class size funding. There's nothing, Justice Perry, this goes to your question, there's nothing here that indicates from the record that there will be any kind of a decrease. Now,
would you? I have a fundamental concern with not necessarily this one, but all constitutional amendments. And if we assume that the citizens of the state of Florida have a certain right, he's asserting, they're asserting the right to funding at this particular level. Could be right to freedom of speech, could be any other right. Where do we draw the line when we propose a constitutional amendment that takes away some constitutional right that presently exists? We've seen it with the Fourth Amendment, we've seen it with the Eighth Amendment, and so where is that? Because this may be a little different, I don't know, but where would you suggest that this line be drawn? Because the amendment does make reference that this is going to be the funding level. Do you understand my question?
Sure. Yes, Justice Lewis. What the amendment does is it allocates responsibility for funding whatever it may be to the legislature. Now, when we talk about a funding minimum or a funding floor or a ratio or any of the other words along that line that have been used here, you'll search long and hard in Article 9, Section 1 to find that there is a constitutional right or a right to a certain level of funding. It's simply not there. And if you look to the history of the way the legislature has funded this, in 2005, it's $1 billion in class size funding. In 2008 or 2007, I think it was $3.3 billion. Then it drops back to $2.7 billion, and then it's trickled up since then. So the whole idea of a floor, that's no floor that you could walk on. It's not a floor at all. It's a
So
political.
you see that the ones that have some type of formula or aspirational basis are far different than those that take away some existing right of Floridians.
Well, it's telling
And that's
it's telling the legislature that this is the obligation. We need class sizes to be at this size. Now, whether you use funding to make that happen or non-funding strategies to make that happen, along the lines of this court's 2002 advisory opinion that pointed out this exact point. You can use funding, you can use non-funding, but the goal here is that the students in the state of Florida have class sizes that meet the targets in the class size amendment. And now in Amendment 8, the targets would be the revised targets. So that's the thrust of the amendment. And whether it's achieved by the legislature using funding or non-funding, that's nothing that is specified in Article 9, Section 1, and as this court has recognized.
So you see this one is not in the category of those cases where there is a requirement that you place in the summary what the citizens are giving up.
Absolutely. This is nothing like ASCU, Your Honor, where there's outright deception involved in changing a lobbying ban to a lax requirement. Nothing like Armstrong, where you're going from cruel or unusual to cruel and unusual and not telling the voters sort of what's at stake. It's not like Amendment 7. Again, there's nothing in Article 9, Section 1 setting a rate, a formula, a floor, or what have you.
Well, do you think that voters reading this could have believed that before this amendment there was no state obligation and they're actually going to vote for something that's going to give them more rights? I think that was what one of Mr. Meyer's arguments is, that this is a situation where there was an existing right, and now as far as the size of the classrooms, that right will be affected by them voting for a different level of classroom size. So is there that potential for it misleading the public into thinking that they are getting something more than they had before?
There is not, Justice Perriente.
But that is one of the arguments, correct?
That is one of the arguments. Actually, it was newly minted before this court. You'll search long and hard in the complaint to find an argument along that line, or the motion for summary judgment, or even in the trial court's order. You won't find an analysis of that particular argument, which goes to a problem with these late filed amendments. To sort of get off, I'll come back, but it goes to one of the problem with these late filed amendment cases. Our plaintiffs here, they're savvy. They're repeat players with respect to filing ballot title and summary cases. They did it in 2008, and here they spend all spring and summer to put together a complaint that they drop on the system and on the state the last week of July, and rush the case through the system. And they present this argument here for the first time, and knowing that we have one business day to respond. And so on that argument, I don't even think the court should entertain it. But if it does, I don't think it has any legs, because going back to an observation that you made at the beginning of Mr. Meyer's argument, if you look to the title of this of Amendment 8 and look to the summary and the title are very clear as to what's being revised here. This is a revision of class size requirements for public schools. This isn't claiming to be a revision of funding or a revision of the legislature's obligation. So the whole idea of having to tell voters that the legislature is currently funding class size when it's always funded class size and there's no change in that respect, on top of this title and the summary, which tells the voters exactly that this is about amending class size requirements, not about any amendment of the funding mechanism. I think it's very clear, and there is no real threat of voters misconceiving that point or what's at stake here.
You mentioned something in response to my question that I just want to get on the table, which is the fact this attack wasn't filed till July. But the position of the state was, because it was filed late, we should just let it go through the normal course. And I, who was part of the Armstrong court, vowed that this court, looking at a amendment after it had already passed or not, after the fact, is a terrible thing. So the state isn't really suggesting that this court should delay an opinion in this case till after the election, are you?
I don't think you need to do that, particularly after we worked long and hard over that weekend to get our refund.
But your position was, the state's position was, you can wait and rule on this after the election. And I don't think that's a very responsible position to be taking.
Well, I think that the point there was, Your Honor, that the ballots have been printed and that we have another month until the election, and so the need to rush and to have one day essentially.
Well, maybe we should have time limits that the legislature and this court work on as far as these legislative initiatives. This court had to essentially drop everything it was doing over the summer, and this happens every 2 years, just about since I've been on this court. So but let's not pick on, we're here on this case now, and so
Sure.
since you had brought it up, I wanted to make sure that clarified the state's position, that you weren't asking us to delay this opinion.
Sure. No, we're not, Your Honor. And unless there are any questions, I think I've covered the points that we wanted to make here today. We just respectfully request that the trial court be affirmed and the voters be permitted to vote on Amendment 8 in November's general election. Thank you.
I can just take an additional minute, Your Honors. The primary purpose of the class size amendment was funding. In Armstrong, the court held very clearly that the ballot language in the present case is defective for what it does not say. It does not tell the voters the chief purpose of the amendment. Amendment 8 suffers from that same shortfall. It does not talk about the funding.
And I realize, because it's your best argument, that you're not willing to agree that there is a pretty large difference between where there is an existing, say, as Justice Lewis saying, constitutional right to that's great for against unreasonable searches, and after voting on the amendment, the voter, the floor is going to be whatever the U.S. Constitution says, essentially eviscerating a right that existed. Or if this was the right of privacy, and they were going to say that from henceforth the right of privacy will be construed like the United States Constitution. Those cases are, to me, very different. This is not changing the fact that the right is for sufficient funding for class sizes. It's just changing what the amount is going to be based on difference in the number of students.
Your Honor, I'm not willing to concede a difference because I don't believe there is a difference. I was hoping that you were going to bolster what Justice Lewis had said. Here we do have a constitutional right that the people of Florida put in 2002. They said, we want a level of funding. I imagine on spring days, if your windows are open, you can hear the legislature howling about having to abide by this unique constitutional provision that says they don't have the broad latitude that they have in funding the court or any other avenue of funding. They have to abide by what the people of Florida said is the base. And they want out from under that. And that's fine. If the people want to let them reduce the base, they should be able to do that. But you've got to tell them that.
It says it's going to reduce the base.
It doesn't say that. What it says is you're going to increase the classroom sizes, you're going to change the way you count kids, and you're going to, reading from the amendment, you're going to provide funding sufficient to maintain the purposes of this amendment. Not only do they not clearly tell you that there's going to be a change, they sort of seduce you into believing that it's continuing what is now. The word maintain is used. You know, we don't see how you can tolerate that kind of omission in a ballot summary that is going to make such a fundamental change to the way public schools are funded.
What is the precise language that presently exists that establishes what you call that base? What is that precise language?
The precise language is where the amendment, Article 9, Section 1, says, to assure that children attending public schools obtain a high-quality education, the legislature shall make adequate provision to ensure that by the beginning of the 2010 school year, there are a sufficient number of classrooms so that these goals are met. And we're changing the goals, but we're not changing, or we're not even telling the voter that by changing those goals, you're changing that language that says adequate provision.
But doesn't that language still remain, even if this amendment passed, that language would still say that the legislature shall make adequate provision to ensure that there are sufficient number, that funds are available for these classrooms? Isn't that language still there even after this amendment assuming this amendment passed?
Clearly the language remains, but it means 20% less in the funding that public school districts get from the state.
And
You're
where do you
changing
get
that
that
funding.
figure from?
Because if you go from 18 to 21, or that's 17% difference. If you go from 22 to 25, that's I think a 23% difference. And if you go from 25 to 30, that's a 20% difference. You're changing the floor. You're moving the floor down by changing the parameters. And the people of Florida are not being told in this summary that that's what they're voting on. They're being told you can put more kids in a class, we're going to count them differently, but they're not being told they're losing money. Thank you, Your Honors. I appreciate the time.
Thank you. The next case on our docket is Dennis versus the state of Florida.
Good morning, Mr. Chief Justice, members of the
You
court.
might wait just a minute.
They're not interested in the rest of our cases, huh? Charles? I guess they're not interested in the rest of our cases.
The court is now proceeding with the next case. Thank you.
May it please the court, my name is Barbara Wolf. I represent the petitioner Clarence Dennis. In 2005, the Florida legislature enacted Florida Statute 776032, also known as the Stand Your Ground Law.
Could you clarify? I thought that the actual statute that said there was no duty to retreat would be found in, say, 776.013 or another substantive statute.
Yes, actually, that's correct.
Because I was looking for, and we're not today here to discuss anything about the merits of that law or any attack on that law, correct?
That's correct, Justice.
Okay. So continue.
776032 is intended to convey true immunity, not merely an affirmative defense. And this is evidenced in the language of the preamble to the Senate bill, which says, whereas the legislature finds it is proper for law-abiding people to protect themselves, their families, and others from intruders and attackers without fear of prosecution or civil action for acting in defense of themselves and others. The issue before the court this morning is how should this statute be implemented by the trial court? In Peterson...
Can I ask you a factual question?
Yes.
Make sure I have clear in my mind. At what point in these proceedings did Mr. Dennis move to dismiss on the ground of this statute?
Prior to trial.
Okay. Was it before or at arraignment? Or was it after that?
Oh, it was after arraignment. It was some months after he was charged, but it was prior to trial.
Did that comply with the time limitation in Rule 3.190C? The defendant shall move to dismiss the indictment or information either before or at arraignment. And there are certain exceptions to that, but they don't seem to cover this.
You know, it appears from the record that it was after that time, but there was no objection in the record to him proceeding with the motion.
You're saying
It's
that's not an issue in this case?
It's not an
Okay.
issue, no.
The conflict is fairly clear as far as how the district courts have dealt with this particular issue. And are you here today advocating for a pretrial hearing where the defendant would have to put on evidence to show by the preponderance of evidence that there was a justifiable use of force?
That's correct, Justice Marianti.
My problem with that is, and I know the other courts have adopted this without really almost any analysis, is it comes from a Colorado case. Where is that idea of a standard of preponderance, of the defendant's burden, and then, you know, the idea that then it would go to, if you lost on that, you go to trial, and then you reassert immunity, and then there's another trial on that. Where does that come from? And if you could, other than the Colorado case.
Right. Well, because the legislature has intended this to be true immunity, this is an important substantive right that the legislature wants the people of Florida to have. And because it's a substantive issue of law, whether or not the force used was justified, it deserves a standard of proof that would examine the evidence.
So if this was, because this applies both for civil immunity as well as criminal immunity, let's take a civil case. Say that the victim is now suing the defendant in a civil action, and the defendant asserts immunity. Was that the same idea that would be a pretrial hearing in a civil case where the defendant would establish by a preponderance of the evidence before the trial began that they had used force, that it would be a pretrial court ruling rather than a jury determination?
Well, in a civil case, the proponent might move for a summary judgment to dismiss the charges. However, there's a difference between the civil and criminal in that in a civil case, each side is entitled constitutionally to a jury trial.
But we're really just talking about the procedure, and that's what, as far as I'm understanding this, the procedure, and the procedure is no different. I mean, as far as the way the language of the statute goes, this statute deals with both criminal and civil action and doesn't make a distinction between how those two cases would be dealt with.
The statute does protect from both criminal prosecution and civil. That's correct.
Going back to just the mechanics of how you bring this to the court. Typically, it seems to me that the typical C4 motion to dismiss it's not well suited for this kind of thing, because basically it's like the equivalent of the civil summary judgment.
That's
where
correct.
Everything's basically done on the pleadings. There's no testimony. So it seems like the C4 motion is not applicable. However, I think Judge Gross over the 4th DCA in Giovanni, he mentioned that there may be another section of the rule that may allow for an evidentiary hearing, which is what you need down below, and that's 3.190B. And because he mentions all defenses shall be made only by motion to dismiss.
That's
and
correct.
Judge Gross mentions, as an example, back in the old days, I don't think they're allowed anymore. There used to be this thing called transactional immunity, where the police would tell someone, the state would tell someone, you're not going to be prosecuted for this if you testify, period. And then, of course, later on, the person is prosecuted, and then he wanted to come in and bring in testimony that he was given immunity. And those type of evidentiary hearings were done pursuant to 3.190B. So it appears to me that there is a provision in the rule that would allow for an evidentiary hearing to determine whether or not this should be a defense that completely precludes prosecution for it. And I think that's the heart of the matter, is how do we proceed with this? How is it handled at the trial level? So I guess that was a friendly question to you, but I take it that's the vehicle that you are going to pursue?
Yes, but regardless, yes, Judge Gross does in Gavani opine that the rules do allow for this procedure. But regardless of whether there's a rule in place or not, this is what the legislature wants for the state of Florida.
Well, I understand substantively that's correct, but the question I have and the problem I have, how do you bring this to the court prior to trial? What you're saying is this is not a defense.
This is not an affirmative defense,
no.
and the statute is clear that it is meant to be true immunity. It is not something just to be raised at trial.
But there are I'm sure there are factual matters involved in how the person used deadly force as to whether or not the immunity should apply. So how do we determine that?
Well, the procedure in Peterson from the first DCA has fashioned a procedure that would allow the trial court to have an evidentiary hearing prior to the trial in which the burden would be on the defendant to prove by a preponderance of the evidence that he was entitled to immunity.
And once that hearing takes place and the trial judge makes a determination, for example, that the defendant is not entitled to immunity, what is the next step?
If the motion is denied, then the defendant would proceed to trial where he would have the ability to raise the affirmative.
Why wouldn't the defendant proceed to the district court with a writ saying, I'm immune and there's an error here, and seek review of that if in the circumstances where there's not been an evidentiary hearing, like in this case?
That's correct, Justice Kennedy. If it were denied, the correct procedure would be then to appeal that to the district court through a writ.
So once he has had his evidentiary hearing, he can appeal that, and if he doesn't appeal that and he goes to trial, were you about to say that he can then raise that as an affirmative defense?
He can raise his justified use of force as an affirmative defense at trial. And there's no authority that I'm aware of that would preclude him from not filing a writ, from not appealing through a writ, but for waiting and doing it through direct appeal.
But I guess what I'm wondering is you would agree, though, since does the state then have an obligation to prove beyond a reasonable doubt that the force used was not lawful?
At trial?
At trial.
Or are you talking about
let's assume what Justice Quince's scenario, and you say it still gets raised. And I thought that the state agreed that this statute does change something because it changes their burden at trial, that you don't, even if it's not raised as an affirmative defense, that they've got to prove beyond a reasonable doubt that this was not a justifiable use of force. Is that correct?
That's correct. That would be the standard for the state to prove any crime at
But
trial.
that wasn't what existed before the Stand Your Ground statute went into effect, was it? Didn't the defendant first have to raise self-defense before it switched to the state, or not? I'm just trying to find out what the burdens you're saying would exist at trial would be after the statute is passed and after there's been already a determination that the defendant's not immune from prosecution.
I'm not sure I understand your question, but I don't believe that the burden for the state has changed. The burden for the state is always to prove beyond a reasonable doubt that a crime has taken place and to prove the elements of the crime.
So the affirmative defense raised would be self-defense, and what would be the standard at trial that the defendant would have to prove that defense? What's the burden at trial for the defendant?
The defendant can raise as a defense at trial that the force he used was justified.
And is there, and what is the jury instructed as to what the defendant's burden in that regard is? Is it different than the pretrial burden of preponderance of the evidence?
At trial, I don't believe the defendant has a burden. I think he is entitled to raise the defense that the force he used was justified.
Well, let me give it to you another way. Let's assume we agree with the 4th District that this is only something that is raised through a C4 motion, or let's say that we agree with the Kentucky Supreme Court that says this is, should be a meaning to the word probable cause, which is what the law enforcement officer has to use, and that would be the standard pretrial, that is probable cause. And now it goes to trial where there hasn't been an evidentiary contesting of the facts. What is then, in order to be able to establish immunity from prosecution, how would the jury be instructed?
Once it goes to trial, there is no, the defendant has lost that right to be immune from prosecution once it goes to trial. So the jury is not going to be instructed on immunity, if I understand your question.
So it would be, and that's why you're saying something has to happen pre-trial.
It must be done pre-trial, or that privilege to be immune from the burdens of prosecution is lost once.
Well, what about in the civil context now? Are you saying that it would be different, that they're supposed to be immune from a civil action, but because we all the time allow qualified or other immunities to be raised and decided by trial courts, by trial juries, that it would have no meaning in a civil case?
Well, once immunity is granted under 776032, that also protects the person from civil action. If the case starts out as a civil action not involving a criminal charge in 776032.
So you think that the criminal case would be binding on the victim who is trying to sue in a civil action?
That appears to be my reading of the statute, yes. That if the person in the criminal case is found to be immune from prosecution, then he cannot be taken on the civil for a civil lawsuit either.
Well, it seems that there's some language in the statute that talks about the person who used the deadly force being entitled to reimbursement for fees and expenses and all of those kinds of things. So it seems to me that there's some contemplation that a person would in fact be either criminally prosecuted or have a civil trial, and that issue would still be before the court, and if the perpetrator wins on that issue, he then gets back his fees and the cost and those kinds of things. So I'm not sure I totally buy your argument there. So what is the purpose of that statute that talks about being reimbursed for fees and costs?
I'm not sure I can address that. Let's see. The court shall award reasonable attorney's fees, cost, compensation for loss of income, and all expenses incurred by the defendant in defense of any civil action brought by a plaintiff if the court finds the defendant is immune from prosecution as provided in subsection 1.
So is that only under circumstances where there was no criminal action at all?
Yes, that would appear to be correct, Justice.
If I understand your argument on this point of civil action, the statute 776.032 says that a person who uses force as permitted is justified in using such force and is immune from criminal prosecution and civil action for the use of such force. Now, is it your position, I think this is what we're trying to get at, is it your position that if a person is prosecuted for this, for using this force, and we have this hearing and the trial court finds that he was immune, that immunity granted in the criminal court carries on over to the civil division, and there need not be a separate evidentiary hearing in the civil court, in the civil side of the courthouse?
Yes, it appears that the intent of the legislature was to protect people who are placed in a position of having to use justified force to protect themselves or their loved ones, and that the
Am I correct in understanding that the implications of this statute for civil cases it's not something that's at issue in this case before us
No,
today?
it's not, and I really, in my preparation, have not focused on the civil side. This is a criminal matter that's before the court.
And I appreciate that, except that there was reliance on subsection 3 for the fact there had to be a court finding, and to me, it sounds like that court finding has to do with a civil action, not a criminal action. And so to the extent that this whole statute is being read together, I don't accept the fact that the idea that it says court finding means that there's got to be a court finding in the criminal action. It looked to me like this was a court finding for the civil action.
That there would be a separate finding by the civil court.
You're now down to about a minute and a half.
I'd like to...
So you can continue, but if you want to reserve some for rebuttal, that's fleeting.
All right, I'll go ahead and reserve the remainder for rebuttal.
Thank you.
Good morning, Melanie Dale Serber on behalf of the state. I would like to begin with the assertion that Florida statute offers any type of absolute immunity is a misnomer in this case, and I think that's been supported by exactly what counsel has said. We have a pretrial determination, and then there's going to be a separate determination at trial, which really is an affirmative defense. There's nothing else it can be at trial.
Are you? I don't understand how you reconcile that with the notion that someone is immune from criminal prosecution. Are you saying that regardless of what is determined, assuming that there is a pretrial determination by the court, and the court determines that the person has a good defense, what happens then?
I'm talking about if there's an immunity pretrial, there's a determination of immunity. If it is denied, then when the defendant goes to trial, it would in fact be an affirmative defense.
Well, that's always been there.
Which is my point.
It's always, self-defense has always been an affirmative defense. I mean, the statute clearly says, is immune from criminal prosecution. That's what the legislature said. It seems to be clear language. I mean, how do you determine immunity? If they wanted it to be an affirmative defense, it would seem they would have said so. But immunity means you can't be prosecuted for it. I mean, that's my understanding of it. So why should someone be prosecuted for something, for an act that he or she is immune from?
Which in turn would explain this case, pre-trial, the defendant has to file some sort of motion. And in answering this question, I want to go back to this case. The motion to dismiss under C4 was filed 7 months after arraignment in this case.
After what?
7 months after arraignment. Arraignment was in September of '06. There were 2 motions to dismiss. Both were filed as C motions. One was a C4, one was a C3. They were not filed as B motions. However, in this case, before you can even go to trial, the defense is raised. There is a hearing held reviewing statements, the traverse, varying evidence, and the materially disputed facts are decided that there's a dispute of the material facts and the defendant has a finding he is not immune from prosecution. Once trial comes without the extraordinary writ filed, it's essentially waived the pretrial immunity. There's no other way to proceed than to go through trial business as usual.
Well, this case may have some issues that are different from other cases, but it is undeniable that in 776032, whether we agree with it or not, that the legislature has said that there is going to be immunity from criminal prosecution and civil action for justifiable use of force. Now, so we're here today to see how the courts should be giving effect to what is now a substantive right of immunity from prosecution. And even though, as I said, I might agree that should be a different way to handle it, it seems that there's got to be a meaningful, if it's raised appropriately, pretrial determination. And the way the 4th District has handled it, because they say there's no other motion or whatever, it would not be. It would be if there's a material issue of fact, then you go ahead with it, and that doesn't seem to me to give effect to the substantive right of immunity. So if you could respond to that we're not here saying whether this is right or wrong, we're trying to figure out how to best give effect to that substantive right.
Well, and I would point to Your Honor's comments regarding summary judgment in a civil case. Nothing has changed. In a civil case, a motion for summary judgment would be filed. That has been the case with respect to immunities in civil actions for many years, comparing it to the civil immunity provided to law enforcement officer. So nothing's changed. A summary judgment motion has always been the proper vehicle to raise the material disputed facts. There should be no difference in a criminal case. The statute was written addressing the defense or immunity for both civil and criminal. There's nothing different to apply here. These cases have been long decided that summary judgment is the proper motion, and that should remain the proper way to address this claim.
Well, I thought at some point in this brief had said that you thought the way the Kentucky Supreme Court handled this would be the way to go.
Yes.
Well, that isn't a C4. Isn't there more that the state would have to put on in a probable cause determination than just or are you saying it's the same as a C4?
I'm saying it's the same as a C4. The state, in showing the probable cause finding, has to present a prima facie case. That can be done by showing the current facts in existence at the time of the motions being filed. And if on the face of those facts, the state has a prima facie case that the defendant's actions were unlawful, then the motion should be denied as a material dispute, and it should proceed to trial. If that answers Your Honor's question. I would suggest that Kentucky is exactly the same as how our courts are already directed to proceed. Nothing has really changed except that the Castle Doctrine has now been codified and expanded to have a pre-trial determination made. Summary judgment has always been the motion filed to determine a pre-trial immunity. This court and courts after it have said a C4 motion is identical to that motion. Therefore, we should continue with our current rules of procedure and proceed business as usual on our criminal cases.
So your position is that you have a motion filed pre-trial to dismiss based on 776.032, correct? And that we have a hearing on that. And the court decides that the defendant has not demonstrated that he or she is entitled to immunity. The next step is to go to trial. Yeah. And at that trial, the issue can still be raised in the form of a self-defense, affirmative defense, correct?
Yes.
And if the defendant prevails on his self-defense motion, on his affirmative defense of self-defense, or is he going to be entitled to recoupment of fees or something?
No, that's the civil. That is solely
I just
relating to the
want-
civil case.
It just seems a little strange to me that we're going to have a hearing on immunity, and then we're going to, if he loses on that, he's going to raise the self-defense, which of course we know has always been there. And how do you prevail? I'm just not sure. I'm quite.
Subsection 3? Yeah, subsection 3 specifically refers to expenses incurred with respect to fighting a civil action. That section doesn't relate to the criminal trial. That is solely the expenses incurred in a civil action. So again, I would say that really doesn't have a bearing on the determination that we're arguing here.
Well, doesn't it actually help your case, because the courts that have said that there had to be a court finding was assuming that was a court finding in a criminal action, whereas subsection 3 only refers to a civil action?
I agree with that, Your Honor.
Previously, when Justice Quince asked people about the process that you think it should follow, file a motion to dismiss, lose it, then you go to trial and use the affirmative defense. If that's the process, how has this statute changed anything? That's the way it's always been. I mean, affirmative defense, what changes?
I would disagree. The statute now codifies a pretrial immunity. The defense counsel cited to some cases that talked about C4 not being the proper way to deal with a self-defense issue.
However, what you're saying that there can never be a pretrial determination that the person is immune. So if there can never be one, then the only thing left is an affirmative defense, which has always been there.
No, I'm saying a pretrial determination of immunity can be based on the facts deduced in a C4 motion and any hearing that takes place with respect to that motion.
But you can't have a hearing on a C4 motion.
I would disagree. There can be a hearing, not an evidentiary hearing in the sense that the defense is arguing. Under the rules, the judge can take any evidence under C4, and the rule, it explains. I could tell it, Your Honor.
Right, but then the state files a reverse, and it requires the judge to deny it.
If the facts are material facts are in dispute, the facts material to the self-defense or the immunity allegation, the reasonableness of the defendant's actions. I mean, granted, there can be lots of disputed facts, but materially disputed facts is a term of art that has been recognized by this court in longstanding case law. So there is a remedy pre-trial. It's not simply, well, some of the facts are in dispute. It's material. The materiality of the facts has to be determined, and whether or not those facts are in dispute. And I think that's an important distinction to recognize there is a pretrial remedy. And in this case, I would argue the issue's been waived. Once the defendant went to trial, he's waived raising this particular case.
I'd like to know how you waive something by not taking an extraordinary writ, and there's no judgment entered against someone, and there's no provision in the rule for an appeal from that.
What I would argue is, looking at the procedure of the case, now we've gone through an entire trial.
Well, that's making a difference. It's a pre-trial motion. It's been denied. You don't lose your right to seek review of that.
I would think under these circumstances and under the rule and the statute, the plain meaning is he can raise the pretrial immunity, but I'm looking at it, it would be nonsensical to say that I continue to hold the right. You're almost backing the state into a corner and giving them no right to appeal any ruling against them once jeopardy attaches.
I don't see any legal theory upon which you can make a legitimate argument that a defendant waives all appellate remedies simply because they don't seek an extraordinary writ with regard to the pretrial ruling. I don't see anywhere in the law anywhere that supports that.
I wouldn't say all appellate remedies are lost. In this case, the case has proceeded to trial. The defendant has filed a motion for judgment of acquittal.
How do you lose the right to challenge a ruling that's never been reviewed?
I would think it's not a ruling that's never been reviewed. Now the defendant at trial has argued self-defense and has filed a motion for judgment of acquittal and a motion for new trial based on the self-defense argument. So it wouldn't, in essence, lose the right to appeal this particular defense, as I would call it.
Well, the two different things. Immunity goes to subject matter jurisdiction, correct?
Correct.
Affirmative defense has nothing to do with jurisdiction.
And I would agree with that, except for under this statute, the legislature has called it immune from prosecution. They've made it a continuum. However, that's really a misnomer, the idea of immunity. It's really a pretrial defense that you can't prosecute me is
Well,
really
but
the
it's a
better way.
You can say it's a misnomer, but that happens to be the word that the legislature used.
I recognize that. But in practice, you can raise the immunity pretrial. I'm immune. You can't prosecute me. And then at trial, the defendant argues it was self-defense. It really is one and the same. However, how you define it based on practice and the plain reading of the intent of the statute is immunity, you can't prosecute me is a continuum. It can be it starts at arrest and continues as they define the word criminal prosecution includes beginning to criminal prosecution.
Well, let me ask you, going back to the Fourth District's opinion in Velasquez, it seemed to me that the Fourth District was struggling with whether there was a procedure in the current rules that would allow a factual determination to be made. And if that's all they were saying, then it seems to me we can, either through what Justice Labarga said or any other procedure, can say, no, you can file this through a rule, whatever we say, because we're talking about procedure. But your argument today is not that the rules are what are hamstringing us, but how we traditionally deal with immunities. Is that your
That's part of
your
the
position
argument,
is?
yeah.
Because you would agree that if it's just the issue, well, you can't do this because the rule isn't in place to do it, all we have to do is amend the rule.
I understand.
So let's go back to the idea of why it is that the concept of immunity from prosecution should be dealt with akin to a summary judgment procedure versus a judge making a factual determination. How do we, in effectuating the legislative intent, make that decision?
I would again suggest we look directly at the plain language of the statute. A person who uses force and as permitted under the rules is immune from criminal prosecution and civil action. There's no change in how to proceed. It's now you can raise it in a criminal case, and as civil cases have already shown us, it is raised in a motion for summary judgment. There should be no change. It's just adding another layer to what can be raised pre-trial. And
well, maybe maybe we should be changing the way it's done civilly. If someone is truly immune from something, then they have a right not to have to be subjected to either a prosecution or a civil action. Why isn't it better to understand that, at least in the criminal case, that immunity should be able to be litigated pre-trial? And, I know that the defendants, at least in one case in the 5th District, sort of said, well, where do we come up with the preponderance of the evidence? We think the state ought to have to bear the burden of showing that they're not immune. And that's why I asked about where that standard came from. But I feel like we're just taking this out of thin air when we're coming up with preponderance of the evidence versus, no, it's going to be dealt with as summary judgment. If it's a true immunity, shouldn't there be a meaningful pretrial hearing?
I would disagree. I would think looking at civil summary judgments and how they've been handled in this state, this type of immunity not to go to trial has been dealt with, and it is a meaningful litigation. You're determining if the material facts are in dispute. The preponderance of the evidence standard, I would agree. There is no place in our laws that we're going to find that standard applied in a pretrial hearing with the defendant proving the burden. A motion to suppress and the examples given are really an opposite. Those are evidentiary rulings, not the whole criminal case. This is essentially giving a judge pretrial under the defendant's scenario the ability to acquit pre-trial when this state has a long-standing history of we prefer to have a jury trial if there's a material dispute in the facts.
What I hear you arguing is that to the extent we're going to have a pre-trial determination and an evidentiary hearing, it's not going to be the defendant's burden, it's going to be the state's burden, and it's not going to be preponderance, it's going to be beyond a reasonable doubt. So are you recommending on behalf of the state that we have an evidentiary hearing pre-trial, the state's burden to prove this defense, call it immunity or affirmative defense, whatever you want to call it in the statute, this substantive right, to prove beyond a reasonable doubt that it doesn't exist. Is that your position?
No, I'm absolutely not arguing that. Our position is a pretrial C4 motion is proper and is a good rule that has been fashioned by this court to use. It's always been used in any type of motion to dismiss. Reading the rule, there are time limits, there are different things that involve whether it's a C1 through 4 or whether it's a general rule under B. However, it is perfectly suited to determine if the state has a prima facie case to move forward. That's what I'm suggesting to this court, that we continue to use our rules as they've been promulgated to decide pre-trial whether or not the immunity defense applies to this defendant.
But if it's just a prima facie determination, it just eliminates the very purpose of the statute, doesn't it?
I would disagree. The purpose of the statute is to give the defendant to argue, a chance to argue to the court, I acted in self-defense. Particularly in this case, the gruesome facts of this case, I think, take it to a different level than the general cases we may be talking about. However, the materiality of the fact of whether or not the defendant acted reasonable is a decision for the judge to make. And if the defendant is truly immune, then from the face of the facts, there will be no prima facie case for the state to prove and go to trial. That's why C4 is the perfect motion to file.
Well, you said it's not analogous to a motion to suppress, but in a motion to suppress, if there is a warrantless search, burden is on the state to prove that there was probable cause for the search, correct?
Correct.
And there is an evidentiary hearing.
Again, I would distinguish a motion to suppress, though. We're dealing with an evidentiary rule. We're not dealing with the fact that the state won't be able to proceed to trial. In a motion to suppress, you're dealing with solely possibly excluding a piece of evidence. That doesn't prevent the state from going to trial. Here, the state would be prevented from presenting all of the evidence that would have been found to prove that this was unlawful.
Well, but it would be switching it to a judge making that determination pre-trial, and they're not. The defendant's not arguing that would deprive them of their right to a jury trial, and the state, I wouldn't think, could make that argument either. I mean, isn't that in a way, it seems like an efficient way to handle it in cases where there is no question but that there was, this was done in self-defense.
I would disagree, and look to the Kentucky decision talking about how such a mini trial could open the door for abuses of that type of a process. Whereas we have a rule in Florida that specifically discusses how and when to file a motion to dismiss the information or indictment, which in essence is exactly what a motion for immunity is, asking the court to dismiss the charging document. And under C4, which is the only procedure that would apply in this particular case, the defendant would have to show there is no material dispute in the facts, and it's obvious from the facts, in a sense, that he is, in fact, immune based on a self-defense claim. However, when the material facts regarding that defense are in dispute under our current rules and our rules and summary judgment comparison from civil cases, that is the proper procedure to use.
Again, historically speaking, going back to what I mentioned earlier, we do have a history in this state of having evidentiary hearings on motions to dismiss pre-trial. We did it in transactional immunity cases back when we used to have that. Why can't we have it here?
I would disagree in the sense, under the transactional immunity cases, as I discussed that in my brief, Judge Gross's dissent, the judge wasn't making credibility findings under those cases. The judges were just, determining conflicting evidence. While there may have been a hearing, there was no credibility finding being made in those cases. So that would be an opposite to the argument being made here. I understand that it would be nice if we had a simple transactional immunity case to compare. But again, I would cite this court to my brief. It's page 25, where I cited the case law that that's not what happens in transactional immunity cases. I also cited McSwain that talked about that wasn't what is contemplated under the 3.190C motions.
Your time is now expired.
I would again ask this court to affirm the conviction and sentence. Thank you.
Thank you.
There are sound reasons why the C4 motion is not the proper vehicle to implement the statute. First of all, allowing the C4 motion to determine immunity renders the statute meaningless because the trial court is required to deny the motion if there's any conflict in the evidence. Well, any case that gets filed, any charges that are brought, there's already been a determination that there's a conflict in the evidence. The state has an ethical duty not to file charges where it is uncontested that the degree of force used was the proper degree of force under the circumstances. So the state is not going to even be filing charges unless there is some dispute in the evidence that the force was not justified. So it would never even get to the level of the motion to dismiss if it was undisputed. But by making the C4 motion the vehicle to determine immunity, it has to be denied every time. And
So what is the motion that should be filed?
there should be a motion to dismiss based on 776032 that would allow the trial court to take evidence and allow the defendant an opportunity to prove by a preponderance that he's entitled to immunity, that the force that he used was justified.
The defendant would testify in such a hearing?
The defendant could testify and put on whatever evidence he chooses that would help him to meet that burden that the force he used was justified.
And where do you obtain the burden of proof, that standard? Help me understand where you say that comes from.
Well, in Florida, substantive issues of law, pre-trial, for example, the example has already been given about a motion to suppress. In a violation of probation hearing, presumption of preponderance of the evidence is the standard used to determine whether or not the defendant has violated his probation. It's a standard that is higher than probable cause, obviously lower than proof beyond a reasonable doubt. And it seems to be a good middle ground for pretrial determinations. It doesn't put the burden on the state to prove beyond a reasonable doubt. It's not a mini trial. It simply allows the court an opportunity to hear and weigh evidence.
Well, it does seem to be almost a mini trial, though. I mean, if you're going to put on exactly what happened, that's a mini trial. I mean, that seems to me to determine whether a person is entitled to the immunity. Except that
in an actual trial, the burden is much greater.
Well, no, I understand, but you say it's not an actual trial, but it is. I mean, it's the essence of the case.
It's an opportunity for the defendant, and the burden is on the defendant at this point to prove why he is entitled to immunity.
But you realize that in another district, another public defender has said no, the burden should be on the state.
Yes. And we're willing to assume that the burden should be on the defendant. It seems proper that the defendant is the one seeking this special privilege, and it would seem very, very difficult for the state to be able to prove that he's not entitled to it. So the burden should be on the defendant to go forward and prove why he is entitled to it.
Your time has now expired. We thank you very much.
Thank you.
The court will now take its morning recess of 10 minutes before considering the last case of the day.
Please rise.
Court will now consider Bionetics Corporation versus Canesti. I'm sorry if I mispronounced that.
May it please the Court. My name is Joe T. Caruso. I represent the appellant, the Bionetics Corporation, and I request to reserve 5 minutes of my argument for rebuttal. The issue before the Court today has been previously addressed by this Court in 3 of its opinions. Those opinions are the Young case, the Ross case, the Bitterman case, and most recently, a 4th case, the Menendez case. All of these cases dealt with the issue of statutory attorney's fees, which the Court has previously held to be a substantive right and a vested right. And the issue in all of those cases, in the case today, is whether or not an amendment to the statute providing for these attorney's fees can be applied retroactively. In the Young case, it dealt with the attorney's fee provision in Florida Statute 768.56, which was a medical malpractice provision. And this court held that it could not be retroactively applied to a cause of action that vested prior to the date the statute became effective, even though the lawsuit in that case had been filed after the effective date.
In this, it seems that the 5th District agreed that this was a substantive right, but then they applied the issue of when the right to attorney's fees would accrue in a different manner. Is that where the conflict is? In other words, I know there's language in there where they say it's a substantive right.
The 5th District in this case found that 57-105, the provision for attorney's fees, was substantive. They found that the amendment was substantive but had a procedural aspect. And they said that because the procedural aspect, the filing of a motion, took place after the amendment, that was the basis for their ruling. So that it was not being applied retroactively.
So but is it the provision we're talking about is the safe harbor provision?
Correct.
And we have approved of Walker in Menendez, correct?
Menendez approved Walker, it approved Bitterman, and all of the previous cases I've cited to you.
But is the issue, what I think the potentially interesting issue is what is the, when does the vested right accrue? In a case like Menendez, it was clear that we said, well, that was an insurance contract case, and the rights accrued at the time that the insurance policy went into effect. Malpractice case, the right not to have attorney's fees would accrue at the time of the malpractice. But here, this is a right of someone not to be subjected to frivolous litigation, correct?
Yes, ma'am.
So would the right accrue at the time that the cause of action is brought, or at the time that the frivolous conduct commences and or continues? Is there a dispute really as to what is the point of accrual, and could you address that?
I think that this court's decision in Bitterman addressed that issue and decided that issue. What the court said in Bitterman, which was a case involving increasing the amendment, increased the amount of attorney's fees that attorney could collect from an estate, and also allowed him to collect in the event he had to litigate the reasonableness of that fee. And what it said in Bitterman is that as soon as the attorney provided its first services to the estate, the rights vested. I would submit that in this case, as soon as the attorney began defending against the claim of tortious interference, which was upon the filing of the first complaint, that the rights vested at that date when the first services was provided. And that is consistent with what the court said at page 634 of Bitterman.
Tell me when the frivolous conduct in this case was the repeated filing of the complaints?
Well, the complaint with regard to tortious interference was filed 5 times. And it was dismissed 5 times and then abandoned before the 5th amended complaint was filed.
And then, did this case involve a jury trial?
No, it did not. It was a bench trial.
It was, and so at the end of the bench trial, the claim, it was everything, all the claims were dismissed?
Well, the subject of the 3 claims before this court never went to trial. The case went to trial on 3 separate claims. So we're dealing today with 3 claims that were pled and at some stage of the proceeding abandoned, with the exception of the violation of the Procurement Integrity Act, which was dismissed with prejudice.
So, and when did the safe harbor provision come into effect with reference to when these 3 claims were dismissed?
All of these claims preceded the filing of the Safe Harbor Amendment July 1st, 2002. The tortious interference claim was filed a year earlier and was filed in August of 2001.
So it would have been, for you even to have filed the motion under the safe harbor would have really, all the frivolous conduct already occurred. There would be nothing that would have changed, and that's sort of a friendly question for you, in terms of you didn't have available to tell them to stop and here's the safe harbor at the time they kept on filing these complaints, correct?
Yes, that's correct.
So if you had what would the safe harbor motion have said? They already did what you're complaining about and was the subject of the attorney's fees, correct?
That's correct. And of course the safe harbor statute went into effect, and oftentimes you don't know that a statute is going into effect. You're not aware that there's going to be some change in the statute. But I would suggest to the court it wouldn't have made any difference because, the rights to attorney's fees are substantive and they had vested already as to all 3 of the counts that we're talking about. I think that the 5th District case relies on 3 cases. That's the Airtran case and the Airtran case, the Hampton case, and the Maxwell case. And even the Hampton case that they rely on was a suit which was filed in 2000, 2 years before the Safe Harbor Amendment. And the 4th District in Hampton said they agreed with Walker and that the amendment affected substantive rights and could not be applied retroactively. And yet, they relied on this case to reverse the trial court's decision. I submit to the court that the 5th District was wrong in several respects. Number one, none of the 3 cases or the 5th District case mentions your controlling decisions in Ross, Young, or Bitterman. The decision of the 5th District is contrary to Walker, and you have ratified and confirmed Walker in the Menendez decision. In Airtran, Maxwell, and Hampton, they ignored the controlling issue. The point in time, the controlling issue is the point in time the party's substantive rights and obligations legally vest under 57-105. And that is when the first services are rendered by the attorney defending the claim, which is the subject matter. The 5th District's conclusion that the controlling factor is when the motion for 57-105 attorney's fees is filed is absolutely flawed. This clearly would result in unconstitutional retroactive application of safe harbor amendments affecting vested rights and obligations to attorney's fees prior to the amendment. The 5th District is in effect trying to accomplish indirectly what they could not do directly. They admit, as Justice Parenti said, that the statute is substantive. They admit that the amendment is substantive and can't be applied retroactively. Yet, they apply the amendment nonetheless because they say it applies to conduct after the statute's effective date. This court in Bitterman rejected that same argument.
But that's not even the facts of this case, is it? As I understood it, in response and reading these briefs, is that the claim for fees is based upon conduct that occurred before the statute was amended.
Yes, that's true. But as this court said in Bitterman, that the claim for attorney's fees for services rendered whenever a statute amendment, it applies to services before the amendment and services after the amendment because they are inextricably bundled together.
We're not talking about, in this case, are we? Services rendered after this amendment.
We are talking about services rendered, yes. We're talking about services rendered until the claim was abandoned.
Until they finally
which
gave up.
Occurred,
It's a repetitive
And that did not occur until after the statute was amended?
Yes, the abandonment of the tortious interference claim and the other two claims, which are the subject matter, were abandoned afterwards. I would, the question of whether or not the Safe Harbor Amendment is procedural, and that's what the 5th District, they found it was substantive, but said it had a procedural aspect, which had to do with the filing of the motion after the Safe Harbor Amendment. That has been disposed of in the case of Antinez versus Whitfield, which is cited in our brief. With regard to the last question, and that was the 5th District decided that the tortious interference claim was not frivolous. And in order to make this finding, they had to determine that Judge Barlow abused his discretion, because that's the standard in determining that the award of attorney's fees was improper. If you look at what the order determining entitlement to attorney's fees that Judge Barlow drafted himself said, is that the court finds that the losing parties or the losing party's attorney knew or should have known when the claim was filed as part of the second amended complaint on July 19, 2001, and at all times thereafter until it was ultimately dismissed by court order November 8, 2003, and thereafter abandoned by plaintiffs, that the claim was not supported by the material facts necessary to establish a claim of tortious interference as required by Florida Statute 57-105 sub A sub 1. I believe that the 5th District, for whatever reason, the basis of the tortious interference count was that Bionetics had interfered with advantageous business relations that Technic-Arts had with Lockheed and with Boeing. They alleged that certain statements that Bionetics employees had made interfered with their future rights to obtain contracts that they would bid on in the future with Boeing and Lockheed. The facts of the case, and if you read the deposition of Mr. Moore, which was filed with the court and in evidence, is that Mr. Moore testified that Technic-Arts bid on the Lockheed contract and was successful. So he has no complaint there. He alleged that both Bionetics and Technic-Arts bid on the Boeing contract, and Johnson Control was a successful bidder. Neither one was a successful bidder. So he has no complaint there. He alleged that there was a follow-on contract to the Lockheed contract, but they didn't bid on it because it was a video contract and their primary expertise was in film, not in video. So if you examine the testimony of the defendant himself with regard to the basis of the claim of what was alleged for tortious interference, that what the Fifth District said is just absolutely contrary to the facts. There has to be an established business relationship for there to be an interference with a business relationship. And the facts of this case, as pled, absolutely did not establish that as a matter of law. And this judge had 5 hearings on motions to dismiss, and in each case found that it was insufficient as a matter of law. And I submit that the findings of the court, which tracked the wording of the statute, were sufficient to meet the requirements of 57-105-1A, and that Judge Barlow did not abuse his discretion. I would reserve my remaining time for rebuttal.
Good morning, Your Honors. May it please the Court. My name is Frank Kennesty, and I'm the respondent attorney in this matter. Your Honors, this Court should affirm the Fifth DCA's decision for 2 main reasons. First, the plain language of the statute under Section 57-105 requires that any motion served after July 1st, 2002 must comply with the safe harbor provision, which requires a 21-day notice before filing the motion for attorney's fees. In this case, it's clear that the petitioner failed to comply with the safe harbor provision. Therefore, the Fifth DCA's decision was correct. Secondly, and as to Justice Parente's question, which is the critical issue in this case, is as of July 1st, 2002, was there a vested right? And I would argue there wasn't for 3 main reasons for attorney's fees. First, petitioner had not filed a motion for attorney's fees. Secondly, all 3 allegedly frivolous claims were still pending. And to your point, Justice Parente, the conduct occurred both before and after the amended statute. It wasn't just before the amended statute. So what you have is a continuing event, not a discrete event like, for example, in a personal injury case or a medical malpractice case where you have an injury on that date. What you have is the initial filing of a complaint and the alleged continuing frivolous conduct that both preceded and was post the amendment of the statute.
But as to all the conduct that preceded the effective date of the statute, which was the filing of these frivolous claims, the safe harbor provision was not in effect at that time to allow someone to say, here, you withdraw this or we're going to file a motion. And isn't that correct?
That's absolutely correct, Your Honor.
So at the most, if your argument is that there was frivolous conduct before and after, that you would at least be responsible for all the attorney's fees for defending these actions that were frivolous before the effective date of the motion. Has anyone argued that?
Well, Your Honor, courts have analyzed it differently. As this Court's probably well aware, 57-105 was modeled after Rule 11. In Rule 11, a similar situation took place in 1993 where Rule 11 was amended to add the safe harbor provision. In the Ritter case that I've cited in my Sixth Circuit Federal Court, they had the same fact pattern, basically amended complaints, 2 or 3 amended complaints. The first complaints predated the amendment to the statute, and then following that, they continued. So what the Sixth Federal Circuit said was that there was no reason why the petition or the litigant could not follow the safe harbor provision. In other words, there was no retroactive effect. A truly retroactive effect is if the conduct's been completed, and then you don't have a chance to change your conduct. Here, that's not the case. What we have is a continuing event of alleged, and I argue that these aren't even frivolous claims to begin with, but assuming they are, you have alleged frivolous claims that precede the statute and go after that. Petitioner had plenty of time after the amendment to file the notice, or alternatively, Your Honor, petitioner could have filed the notice before the amendment or filed a motion before the amendment without notice. He had two opportunities, either before the amended statute took place, file the motion. In that case, I would argue he probably would have a vested right to seek fees. Or after the amended motion, he had a simple procedure. All he had to do was provide a 21-day notice, which he failed to do. And I cited in a notice of supplemental authority the U.S. Supreme Court case, the Thorpe case, which was a similar issue of retroactivity. If you have, in that case, you had the housing authority, it was the housing authority, the Thorpe versus Housing Authority. In that case, the housing authority changed their regulation for eviction. The eviction was started prior to the amended regulation, but during the preceding, the regulations changed, and similarly, the regulation required a notice requirement. And what this U.S. Supreme Court found is that all that the housing authority had to do was follow the fairly simple procedure of providing notice, and there was no retroactive effect.
But it seems to me that your argument would almost lead to this result with the safe harbor provisions, which is that an attorney who starts to defend a lawsuit or it could be the other way, an attorney who is forced to respond to something that the defendant files that's frivolous, would start to have to, each time there was a frivolous action, would have to be filing a motion for attorney's fees to say, and ask them to cease and desist. Right. And then instead, there would have to be a series of motions for attorney's fees? Isn't that what your argument would lead to if there's not if there's a safe harbor provision and you're trying to get them to stop what they're doing?
No, Your Honor, that's not what I'm arguing. I think going back to the intent of the safe harbor provision and the rule itself, as this Court is aware, 57-105 was modeled after Rule 11, and the main purpose of this attorney's fees statute is to deter frivolous claims and to ease the procedure of the court. In other words, to have the attorneys police themselves.
Right, and at the time when this lawsuit was filed, right, which the defendant deemed to be frivolous, right, they had a right to expect that if it was determined to be frivolous, that they could recover their attorney's fees without having to go through extra hoops, and that's really what isn't that the substantive right that's been altered, which is that now no longer do you get attorney's fees, you got to ask them to stop what they're doing before you can file your motion. Well, here's the problem with that argument, Your Honor, is that, and your question goes to the central point, is when does the right to attorney's fees vest? Now, if you take petitioner's argument, the right to attorney's fees vests when you first file your complaint, that's assuming there's been no evidence taken, there's been no discovery. That's saying that the moment you file, the claims pled are frivolous. And that would go in direct contradiction to this Court's holding in the Lombardi case, which, as this Court is aware, motions to dismiss, you assume the facts pled in the complaint are true. So if you say the facts in the complaint are assumed as true, how can you have a vested right by just saying that they're frivolous? That doesn't comport. So what I would suggest, Your Honor, is the analysis has to be is when do the right to attorney's fees vest? And I point to the cases that I provided in the Notice of Supplemental Authority, which was the Wisconsin cases. The Wisconsin Supreme Court now analyzed their attorney's fees statute, which was modeled after Rule 11. In that case, the Trinity case said the right to attorney's fees vest when the trial court makes a finding of frivolousness, that not when it's filed or not any other time, but not until the court makes a finding of frivolousness. I would point to the plain language of the statute, which I think supports that contention, because if you look at 57-105, it states that upon the court's initiative, a motion or a party, it goes on, but it's the essential point is when does this have to take place? And near the end of the statute, it says, when initially presented or any time before trial. So to Mr. Caruso's point, yes, it does say when initially presented. That's when the court can make a finding of frivolousness. But it also could be any time before trial. For example, you initially file a complaint and you believe in good faith
there was evidence to support it. During discovery, perhaps your witness recants or some other facts come out, and then you find it's frivolous. So a right to attorney's fees under 57-105, by the plain language of the statute, doesn't necessarily accrue or vest when initially presented. It could happen because of certain circumstances during the conduct of the litigation. So by the language of the statute, it can't accrue only when initially filed. And I'd also point to, I think there's a distinction between accrual and vesting. Accrual under the dictionary, Merriam Dictionary, is when something comes into existence as a legally enforceable claim. Under section 95.031, accrual of a cause of action occurs when the last element constituting that cause of action occurs. Well, when did the last element of the cause of action accrue under 57-105? Well, you look at the language of the statute, it's not until the losing party or losing party attorney on the claim or defense or any time during a civil proceeding in which the court finds the losing party or the losing party's attorney knew or should have known that a claim or defense when initially presented to the court or at any time before trial, and that goes on. So the trial court...
that last part's pretty important because it's saying that a court can find that it goes back before.
It can, Your Honor, and I'm not arguing that, but the point is accrual doesn't automatically happen when initially filed or any time before trial.
But it could.
I agree. Okay. So question in this case, when did it happen? The facts of this case are this was a motion practice, and I concede the fact that there's probably too many filings in this case, and that was an error on my part. However, in good faith, we filed those claims, and there's no evidence in the record to suggest they were frivolous. But
well, except that the judge has determined otherwise. We're not here today to debate whether it was frivolous or not.
Right.
And the judge has determined from the get-go these were frivolous claims.
Your Honor, he did, but he also, there's several other problems with the case. The fact that the judge and the petitioner in error filed in his motion, he filed a claim that never, or asserted the claim was never filed in this case. And he uses the term tortious interference in a general term, but the count that was filed in this case was tortious interference with business relations, not tortious interference with a contract, which is a completely different claim. They're similar. I mean, it's similar to battery and assault. I mean, in this case, the trial court got it wrong. The trial court got it wrong because the petitioner argued the wrong claim. But having said that, I want to go back to the vested right issue, Your Honor, is that, I want to add a couple points that I didn't bring out in my brief after I read the Weingrad case with regard to what a vested right is. And in that case, the third DCA quoted Justice Kennedy with regard to what a vested right is, and it says, to be vested, a right must be more than a mere expectation based on an anticipation of the continuance of existing law. It must become a title, legal or equitable, to the present or future enforcement of demand. And I think in this case, at the point of July 1st, 2002, what was the status of the affairs? Was there a vested right? I would argue no, Your Honors. There was an expectation perhaps on the part of the petitioner that he was going to get attorney's fees if the court made a finding of frivolousness, but that wasn't the case at this time.
But isn't that, what's the name of the case where we decided that the losing party having to pay attorney's fees in a malpractice case was something that did not exist before? Was that one of those 4 cases that you mentioned?
Yes, Your Honor. That was presented in the Weingrad case. I don't recall the exact name of the case.
But your argument there would be that the defendant in a malpractice case wouldn't expect that they're going to be liable for attorney's fees until they lose, and they don't lose until after the date that the attorney's fees provision went into effect, and that's not how we've looked at this. We've looked at it as of the time of the filing, or that is when the right, that the substantive right is looked at, and I think we'd be changing a whole lot of case law if we would take your position that not until there's a determination of frivolousness or a determination of that someone's the winning or losing party, that you look at the law at that time as opposed to at the time that the case is filed or the action accrues.
Well, Your Honor, with all due respect, I think this court in Menendez, of course, that case had to do with a contract right, which I think vests a different time. I mean, I don't argue the point. When you enter into a contract, that's a vested right. But here, what we're talking about, in essence, is essentially kind of a tort claim, for a frivolous lawsuit. So the question becomes, when does that right vest? And I would argue the Wisconsin Supreme Court case is correct. But I'd also like, in the fact that it vests when you make a finding of frivolousness. But I also want to make a distinction, which I didn't bring about in my brief, that I think there's a distinction between vesting of the right to seek fees versus the right to attorney's fees themselves. For example, if petitioner would file a motion prior to the amended statute, he would have an expectation that he wouldn't have to provide notice because there was no amendment at that time. But he would have a right to seek fees under the laws of that time.
But he would not have been able to, because does the rule allow an assessment while the litigation is still going on with regard to those issues prior to this amendment? You're saying that he could have, a week after the lawsuit was filed his motion for attorney's fees for frivolousness?
The statute specifically says at any time during the course of the litigation he could file.
So he's free to file that?
He's free to file any time he wants. So what I'm saying, Your Honor, is that he could have filed it prior to that time and he would have a vested right to seek fees. Now, with respect to the vested right to obtain fees, that's different. And I think the Wisconsin Supreme Court didn't address that. They said you have a vested right to obtain fees upon a finding of frivolousness. What I would suggest to the court is that you make a distinction between the right to seek a remedy, and it makes sense, like from a contract standpoint. I have a lawsuit, the law's in effect at the time, I filed the motion. The petitioner filed the motion after the amended statute. Why should he have an expectation after the statute was amended he doesn't have to file notice? That doesn't make any sense. Same thing with contract law. When you sign a contract, the law of the contract at that time, that's the expectation you have. There's no retroactive effect here because petitioner was on notice, the amended statute had been changed, he had adequate time, and the facts of this case is the tortious interference with business relations claim was continued more than 5 months after the amended statute. Matter of fact, it was the third amended complaint. All his petitioner had to do was file the notice, which he did not do. Alternatively, as I said before, he could have filed the motion without notice prior to the amendment, and I would argue he would have a vested right to seek fees under the laws at that time, Your Honor. But this is not a case. Where there's unconstitutional or any retroactive application of the law. And I point to the Landgraf case, the U.S. Supreme Court Landgraf case, which said that conduct antedating a statute doesn't necessarily have a retroactive effect. The critical distinction is with respect to a completed and a continuing event. This court in Menendez said the following: the central focus of a retroactive application of a statute is whether the application of the statute attaches new consequences to an event completed before its enactment. And this court relied on the U.S. Supreme Court in Landgraf. The facts of this case are all three allegedly frivolous claims were pending, i.e. no completed act. And the language of the statute says, I quote, when initially presented or any time before trial. So to your point, Justice Lewis, it could happen when initially presented, but this is not a discrete event, it's a continuing event. So what did petitioner have as of July 1st, 2002? The claims were pending. No motion had been filed, no judgment or disposition to enforce the rights, no finding of frivolousness. In fact, we're still in the stages of discovery. So I would suggest this is very similar to the fact pattern of the Thorpe versus Housing Authority, is that there's no retroactive effect here. I would point to the Wisconsin Supreme Court cases and its companion cases, which had the same fact pattern and found that you should apply the amended statute to this fact pattern. I will also...
Could you have application of two different principles here, that up until the time that the statute was amended, But whatever rights existed, and they may be entitled to fees for that, but once that statute was amended, that any services performed after that date, pursuant to which they did not provide the notice, that they would not be entitled to.
Your Honor, I would argue that, the second part of my argument was what they waited too long to, file the motion for attorney's fees, is that by waiting, that they essentially waived it under Rule 1.525. And I know the rule has been amended recently. I saw the amendment that what happened here is they waited longer than 30 days after these claims were dismissed.
Well, then are you saying that there's a mandatory requirement that after a first frivolous act takes place, if you don't file it within 30 days of that, you're out of court?
I think it's a stretch.
I think it is a stretch.
I think it's a stretch, Your Honor. I argue that point because I think the rule was unclear, but I think the new rules have already clarified that. You can wait till after the trial.
Plus, our case of Gans said specifically, is extremely difficult, if not impossible, for a party to plead in good faith its entitlement to attorney's fees under 57-105 before the case is ended.
That's an excellent point, Your Honor, but Gans was under a different substantive...
But that's where they were...
Right.
They had a right to rely on that case as far as when they were going to file their motion.
Excellent point, Your Honor, but that Gans... The whole lawsuit had to be frivolous. As you're aware, in the 1999 statute on 57-105, it could be any claim or defense.
Well, we sure don't want to encourage attorneys to file serial motions for attorney's fees.
I'm not. In closing, Your Honor, what I would suggest is that there's also a fundamental due process concern here with regard to notice. In this case, the facts of the case, there was no proper notice provided as to what claims they were going after and why. There's no evidence in the record. You examine the record, other than the pleadings. Now, admittedly, there were multiple pleadings, but just a dismissal of the pleading on itself is not a basis for a frivolous lawsuit. I would respectfully request that the court affirm the 50CA's decision in this case.
Thank you.
Briefly in rebuttal, counsel referred to Federal Rule 11. Federal Rule 11, as the court knows, is a rule of procedure. It is not a substantive rule, and the Florida cases cited in our brief of Kaufman and Mullen have already said that the Federal Rule 11 will not be followed in Florida if it, as applied, would affect substantive rights. So that's why the cases that you cited, the Wisconsin cases and the cases of the Supreme Court, are misplaced. Two, the Ritter case, which was the Housing Authority case. The Housing Authority case had to deal with North Carolina or federal regulation that says the Housing Authority had to have a contract with the party, and either party could terminate it upon 30 days' notice. They amended their procedure so that you also had to give them a reason for the termination. But it did not change the lease between the parties. It did not change the terms of the lease between the parties. It did not change the right to terminate the lease. And so what the court said is that it was a procedural aspect because it didn't change anybody's rights. It merely added that you had to give them a reason why you were terminating, and that's why the Ritter case is not applicable. The Bitterman case, this court's decision in Bitterman says that, and it's clear, that the right to attorney's fees vest as soon as the services begin to be rendered defending or acting upon whatever the services are for. The attorney's fees in this case began to be rendered in defense against the frivolous motions as soon as the motion to dismiss was filed in the beginning and proceeded.
Would this be a different case if, say, they had had 2 or 3 valid claims, and then after the date of the statute, a 4th claim was the safe harbor statute, a 4th claim was added, and that claim was the frivolous claim? Would that be a different analysis, or would you still go back to when the first services were rendered?
Well, I think if the claim was first raised after the amendment, I think it'd be a different situation, because no services would have been rendered before.
In defense of the frivolous claim.
Correct, as to the frivolous claim. So I think that would be totally different, and that's not your facts pattern here. But in Bitterman, the court made it clear that the time that the services begin to be rendered is when the right and entitlement to attorney's fees vest. This court in Bitterman adopted Walker, reaffirmed, ratified Walker. Walker is the only case that says that the Safe Harbor Amendment does not apply to cases filed before the amendment went into effect. And therefore, since this court has ratified Walker, then what he's asking you to do is to reverse Walker or to ignore Walker. The argument is that Judge Barlow inadvertently, in his order, referred to tortious interference with contract instead of tortious interference with business relations. What Judge Barlow did is he dismissed 5 times what was pled. What was pled was tortious interference with business relations. He dismissed it 5 times, and then it was abandoned. So the inartful use of the word contract instead of business relations, which was a misnomer, should not cause this court to not reverse the 5th District Court of Appeals. So what I ask the court to reverse the 5th District Court of Appeals decision and to reinstate the trial court's judgment. Thank you.
Thank you. Thank you both. That is the final case for today. Court is now adjourned.
Please rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.